Thank you very much for the invitation, and being here with Armenian friends is an honor for me, and is also the possibility of answering these questions you have raised, which are deal with the responsibility of international community towards the conflicts. And this is exactly what I have already prepared. And after that, I will answer to the two questions you have posed earlier. So the forced displacement of the Armenian population of Artsakh constitutes another blow to the international law and order, proving once again that the line between international order and international disorder is too thin and fragile. Following Azerbaijan's new military assault and aggression in September 2023, nearly the entire Armenian population were forced to flee their homes in a matter of days. This exodus occurred in the context of a 9-month blockade of the Lachin corridor, which was the sole lifeline at the time connecting Artsakh to Armenia and the rest of the world. Although the blockade, firstly, and the violence of the assault were by their own nature a clear and flagrant violation of both customary international law and its norms, nobody seemed to bother. I'm very sorry to say that the case of Artsakh reveals the major disadvantage and weakness of the international law. That is, its failure to be implemented when politics do not want nor dare to bring the perpetrator into account. I come from Cyprus. In 1974, 230,000 Greek Cypriots were forced to flee their homes as a result of the Turkish invasion. Turkey never paid the cost of its actions of aggression, no matter of the raw violence and the audacity violation of international law, despite all these 50 years of occupation. Now Turkey controls and occupies more than 1/3 of Cyprus territory. In order to understand the double measures and standards you have already mentioned in international relations, one has to stress that, on the contrary, the Russian aggression against Ukraine has unified nearly all in the globe against the perpetrator. It is unfortunately obvious that international law applies depending the perpetrator and when national interest demands so. Otherwise, a peculiar immunity exists for the perpetrator. Unfortunately, Azerbaijan enjoys this immunity, despite the fact that both the blockade and the assault, which led to the ethnic cleansing, collided with binding International Court of Justice order issue on the 22nd of February 2023 and constitute a violation of humanitarian and conventional international law, respectively. Ethnic cleansing encompasses acts that are crimes under the Rome Statute of the International Criminal Court, such as deportation and forcible transfer of population, persecution against the groups, national groups, inhuman acts causing great suffering. Returning to Cyprus, in 1974, the ethnic cleansing included mass killings, mass rapes, large scale of lootings and destructions, which forced the population to flee. Needless to say that ethnic cleansing may also amount to genocide under the Genocide Convention of 1948, when it is carried out with the intent to destroy in whole or in part a national, ethnic, racial or religious group. It is obvious that what happened in Artsakh constitutes at least an attempt to genocide and cultural genocide through the deliberate destruction of the historical, traditional, and religious sites, and the liberty exercise of force for fear. Universal Declaration of Human Rights, the International Covenant on Civil Political Rights, the UN General Assembly Resolution of 1948, the customary international law, the International Court of Justice, and the International Law Commission all provide and protect and recognize the right of every individual or group of people to return to their homes in safety and dignity, especially when their displacement was the result of ethnic cleansing. Having said that, the question which emerges is what is the responsibility of the international community in international relations and international law? Its first duty is to establish and found an international order based in the rule of law. International law must be enforced and prevail no matter of the perpetrator, the victim of an unlawful action or omission. Being members of the international community do have the right and the obligation to demand the universal and uniform application of law and international order. This brings us to another question. How can this goal be achieved? I see no other answer than the imposition of the accountability in international relations. Accountability of the state which violates the international norms of order, which is provided also in the Chapter 7 of the UN Charter. This can only be achieved through coercion, binding measures, either provisional or final, by the international courts or organizations, and of course, sanctions against the perpetrator. Telling now in Artsakh, what and which of these measures or actions were finally applied? None. Why? Politics, national interest, petrol, gas, energy, pipelines. Artsakh, and not only Artsakh, reveals the failure of the international community to bring the state who fails to comply with the international order, who violates the international obligations in front of its state responsibility. International community witnessed also the failure to comply with the international humanitarian law under the Geneva Convention. That was more than obvious in the case of Latchin Corridor and continues today in Gaza or Darfur. Ladies and gentlemen, we need a new international order based on real and concrete, non-volatile principles, according to which any violator or perpetrator must be brought before its responsibilities. We need an international community with open eyes and ears, willing and able to act. Historically, the impunity leads to the repetition of a crime, and this is what we witness today in Gaza, in Darfur, in Artsakh. What we really need is international accountability of any aggressor or violator or invader. This stance presupposes that international norms and principles must prevail towards narrow-minded and incompetent leaderships worldwide. What can then do politicians or peoples? The answer is going back to another August. The answer is difficult and simple. In August 26, 1789, in France, la Déclaration des droits de l'homme et du citoyen was adopted in France. One of the striking passages of it is that l'ignorance, l'oubli ou le mépris des droits de l'homme sont les seules causes des malheurs publics et de la corruption des gouvernements. In English, is that ignorance, forgetfulness, or contempt of human rights are the sole causes of public misfortunes and government corruption. There is only one way, difficult but simple, not to give up the right to return and the human rights in general, not to give, not to expropriate the human rights. There is a proverb, Indian proverb in Canada, there is no peace in stolen land. So, having this in mind, the answer to the question is that can we close Artsakh issue? Of course not. Why? Because Artsakh is a matter of human right protection. Nobody, not a prime minister, nor a parliamentarian, nobody can give up, can surrender, giving up the rights of the individuals. That's why the human rights are universally applied. They cannot be given up by any treaty. The second one, can we have peace? The Indians have already answered many centuries ago. As soon as there is stolen land, there cannot be any peace. So let us therefore be loyal to our panhuman and universal values, rigorous and steadfastly committed to freedom, democracy, and justice, demanding equal treatment. Fear not. Forget and surrender not. Giving up, never. Thank you very much.